Imagine this scenario. The unthinkable happens, someone close passes away, you're dealing with grief, all the personal things, and then suddenly there's this legal process. You're facing piles of paperwork, terms like probate, and it honestly feels like being lost in a maze.
Oh.
It's just a really daunting prospect for anyone. So today we're actually going to dive deep into that exact maze. Probate, it's a word that, well, it often brings up feelings of complexity, maybe mystery, even a bit of dread for a lot of us. But what is it exactly? How does it really work? And like, what do you actually need to know? We're going to unpack it all step by step.
That's so true. The whole probate thing can feel incredibly opaque. A lot of people feel completely lost, maybe overwhelmed. So our goal today in this deep dive is really to demystify it for you. Cut through the legal jargon, provide a clear, concise understanding. We'll look at the key stages, the really crucial roles, and sort of highlight why each step matters so you walk away feeling informed, hopefully empowered.
Okay. And to guide us, we've looked at a whole range of estate planning resources. We're breaking probate down into these manageable stages using general principles that, well, they mostly apply across the board. We might touch on specifics like California, maybe, just to give a clearer picture. Because while the exact details, they definitely vary state by state and, whether there's a will or not.
Right.
That basic roadmap, the sequence of events, it's actually pretty consistent.
That's a really crucial point to make. Probate, at its heart, is a court-supervised process. Its whole purpose is to make sure a deceased person's estate, that means all their assets and their debts, is handled correctly, make sure debts get paid, assets get distributed, either according to the will, if there is one, or according to state law, if there isn't. And it's important to realize this isn't usually a quick thing. Depending on how complex the estate is, or if, disputes pop up, this whole journey can take months, sometimes even years, to fully resolve.
Right, months or years. Okay, so if this whole process needs to start, where does it actually begin? Like, what's the very first move?
It all kicks off with what's called step one, filing the petition, basically opening the estate. This is the very first formal document that goes to the court.
And where does someone file that? Is it based on where they lived or maybe where most of the property is?
Good question. No, it's filed with the probate court in the specific county where the person who passed away actually lived at the time of their death. It's tied to their residence.
Gotcha. So who's the one responsible for doing this filing? Is it always the same person?
Not necessarily. If there's a will, then the person named in the will as the executor, well, they're the one who steps up. They file a petition asking the court to accept the will, that's the admit to probate part, and to officially appoint them as the executor.
Okay, that makes sense if there's a will. But what if there isn't one?
Right. If there's no will they died intestate, then usually a close relative steps forward. Often a spouse or maybe an adult child. They file something slightly different, maybe called an application for administration. They're asking the court to open the estate and appoint them as the administrator. As one source puts it, this initial petition requests to admit the will to probate, if there is one, to formally appoint the petitioner, and really to get the whole probate process started.
Okay, so legally speaking, why is this petition so critical? It sounds like more than just, filling out a form.
Oh, absolutely. It's much more. Because until this petition is filed, and until a probate judge actually initiates the process based on it, nothing else can legally happen with the estate. Seriously, no debts paid, no assets managed, no distributions made, nothing. And crucially, until the court issues those official documents, they're often called letters testamentary if there's a will, or letters of administration if not the person, the executor or administrator. They have zero legal authority to act for the estate. So yeah, this first step isn't just important, it's like foundational. It's the absolute key that unlocks everything else.
Okay, so the key is in the ignition, the estate's officially open, someone's got the legal green light. What's next on the map?
Right. So once that petition's filed and the court sets a hearing date, the next really crucial phase starts. Step 2, notices to heirs and creditors. The executor now has this mandatory legal duty. They have to notify all the interested parties about the probate.
And who counts as an interested party? Is it just family or is it broader than that?
It's definitely broader. Written notices have to be mailed out to all the known heirs, anyone specifically named as a beneficiary in the will, and importantly, any known creditors.
Okay, known creditors. But what about debts the executor doesn't know about?
Exactly. That's why most states also require publishing a public notice, usually in a local newspaper. That notice often has to run for a set period, maybe like 3 weeks or so.
Okay, that makes sense. So that public notice is like casting a wider net to catch any unknown creditors or maybe even errors the family didn't know about.
Precisely. The sources stress this.
Mm.
Send notices to the known parties, but you also must publish public notices in the local newspaper. If we step back and look at the big picture here, the purpose is all about transparency and preventing future problems.
Right.
It lets everyone with a potential claim, whether it's an inheritance or an unpaid bill, know what's happening. This helps head off disputes down the road, make sure no one's forgotten. It aims for a fair process.
Okay, so notices are out, published, everyone who needs to know theoretically knows.
Right.
What actually goes down at that court hearing? What's step 3?
Step 3 is the court hearing, sometimes called the petition hearing. So at this scheduled time, the judge takes a close look at that initial petition and all the related documents.
And assuming everything looks good, the paperwork's right, nobody objects.
What happens then? Well, if everything is in order, and importantly, if no one formally contests the will, the court will typically validate the will, if there is one. And then this is a key moment. The judge officially appoints the executor or administrator. They might even swear them in right there. After that, the court issues those really important official papers we mentioned earlier, letters testamentary for an executor with a will, or letters of administration for an administrator without one. These letters are the official proof of their authority.
So those letters are basically their official badge, their legal license to start managing the estate.
That's a perfect way to put it, yeah. One source points out that at this hearing, the judge will verify that the will is valid and will admit it to probate. They will also formally appoint the executor, alternatively, the administrator. What's interesting here, I think, is that while this hearing might seem like just a formality if everything's straightforward, it's actually the legal turning point. It's the moment that legal authority truly shifts to the executor or administrator. It's like a critical checkpoint, making sure the will's okay and the right person's in charge before they start, messing with assets.
Okay, makes sense. So the executor's appointed, they've got their official letters, their powers confirmed. Now, I guess the real detective work starts, figuring out exactly what the person owned.
You got it. That leads right into step 4, inventory and appraisal of assets. The executor's next big job is to compile this really detailed list and inventory of absolutely everything the deceased owned.
Everything, like not just the house and the bank accounts, but literally.
Yeah.
Everything. I'm picturing someone sorting through closets, finding old collections.
Pretty much. The inventory covers real estate, bank accounts, stocks, bonds, any investments, all the personal property, yes, even valuable collections, and any business interests they might have had. In fact, many states require more than just a list. They demand a formal appraisal for certain types of assets, especially things other than cash, like real estate or valuable art. And this detailed inventory often has to be filed with the court.
Wow. And the executor isn't just listing things, right? They have to protect this stuff too, doing what could be a long process.
Oh, absolutely. That's a huge part of their job, safeguarding the assets. That might mean collecting rent if there's a rental property, making sure investments are secure, keeping insurance paid on a vacant house, preventing damage or loss. And for valuing those non-cash assets, they often need help. They might use what's called a probate referee or hire professional appraisers. Like in California, they have official probate referees specifically for valuing property in probate cases. Their appraisals go into the court file.
Okay, but why all this intense detail? Why is such a meticulous inventory and appraisal so vital? It sounds like a ton of work.
That really gets to a critical point. This inventory. It forms the absolute financial foundation for the entire estate settlement. Think about it. Without a truly accurate and complete picture of all the assets, how can you possibly pay the debts correctly? Or figure out if any taxes are owed? Or, most importantly, distribute the remaining assets fairly and legally to the right people? It's all about accuracy and accountability.
Right, okay. So once you know exactly what the estate owns, the next logical step has to be tackling what it owes. Time for the bills and taxes, yeah.
Precisely. That brings us smoothly into step 5, paying debts and taxes. The executor now takes the estate's assets and starts paying off all the valid claims and obligations.
What kind of debts typically get paid first? Is there an order?
There often is a legal order of priority, but generally this covers things like funeral expenses, final medical bills, any outstanding loans, credit card balances, basically all legitimate debts. And remember those notices back in step 2. They gave creditors a specific time frame to submit their claims. The executor has to carefully check each claim, make sure it's valid, and then pay the approved ones using estate funds.
Okay, and taxes, that's a big one too, right? The executor handles all the tax stuff.
Yep, that's another major hat they wear. They're responsible for preparing and filing all the necessary tax returns. That could include the deceased's final income tax return, potentially state inheritance tax returns depending on the state and the beneficiaries, and maybe even federal estate tax if the estate is, well, very large. That federal one usually has a deadline of 9 months after death. When you look at this whole step, what does it really tell us about the executor's role? It really underscores their fiduciary duty. That's a legal term, meaning they must act in good faith, with complete loyalty, and always in the best interest of the estate and its beneficiaries. They're managing someone else's financial legacy, which is a serious trust. As one guide puts it, the administrator receives all legal claims and pays off the outstanding debts. And the executor's duties include ensuring that all debts are paid, including taxes. This is really the stage where the estate's final value starts to crystallize after all the obligations are cleared out.
Okay, so debts paid, taxes filed. What's left is what can actually go to the heirs. How does that part get figured out? How do we get from that final pot of assets to distributing it?
Right. That leads us to step 6. The distribution plan, which is sometimes called the settlement phase. After all those debts and taxes are settled, the executor prepares a very clear, detailed plan for how to distribute whatever assets remain.
And this plan isn't just the executor's best guess, right? It has to follow strict rules.
Oh, absolutely. It's legally binding. The plan must strictly follow the instructions written in the will, if there is one. That's paramount. If the person died intestate, meaning without a will, then state law dictates exactly how the assets get divided up.
So the will is like the deceased's personal rule book, but if they didn't leave one, the state has a default rule book ready.
That's a great analogy, yeah. But if there's a will, it spells out who gets what. If not, state intestacy laws usually prioritize the surviving spouse and children first, then maybe parents, siblings, or other relatives, depending on the family structure. The executor then submits this proposed distribution plan to the court for formal approval. Often, this involves filing a final petition for distribution and getting receipts from beneficiaries showing they agree or will receive what's planned. What's really fascinating about this step is just how precise it needs to be. It's not just a rough sketch. It has to account for every single remaining asset and clearly state who gets it, ensuring it perfectly aligns with either the will or the state law. This plan is basically the final court-approved roadmap before assets actually change hands.
Okay, and then the moment everyone involved has likely been waiting for, the actual handing over of the property. How does a final transfer work?
That brings us to step 7, final distribution. As soon as the court gives the green light to that distribution plan, the executor can finally start transferring the property to the designated beneficiaries.
So this is where the rubber meets the road. Signing deeds, moving money, retitling stocks, handing over personal items.
Exactly that. It's the physical and legal transfer. Legal title for every asset gets formally moved. Deeds for real estate are signed and recorded. Stock certificates or investment accounts are retitled in the beneficiaries' names. Bank accounts are closed out and the money dispersed. Personal belongings are delivered. As Trust and Will puts it, once debts are paid, the executor will be authorized by the probate court to distribute remaining assets per the decedent's wishes. And if there wasn't a will, those intestacy laws determine who the beneficiaries are, typically spouse, kids, or next of kin. This is really the concrete payoff of the whole lengthy process.
Okay, assets distributed, heirs have received their inheritance. Is that the end? Or is there one last legal step to tie everything up?
There is one final, very important step. That's step 8, closing the estate. After all distributions are complete and accounted for, the executor files a closing statement, or maybe a declaration of final distribution, with the court.
And what does that final piece of paper achieve? What's its purpose?
It's the official full stop. The court reviews it, and if everything's in order, it officially discharges the executor from any further duties or responsibilities for that estate. It also confirms that all the necessary paperwork, like the final accounting, receipts from beneficiaries, proof of tax payments, is on file with the court. You might naturally wonder, why is this formal closure so significant? Well, formally closing the estate provides that crucial legal finality. It ends what can be, as we've discussed, a really long and involved process. It officially releases the executor from their demanding role and their fiduciary duties. And honestly, it often provides a sense of emotional closure, too. It signals that all legal obligations are fulfilled and the estate is truly settled.
Phew. Okay, wow. That was an incredibly thorough walkthrough. From that first petition all the way to the final closing. We've really tried to break down what can feel like a super overwhelming legal system. Let's just quickly recap the big picture.
Absolutely. So to boil it down, while probate definitely has variations from state to state, It almost always follows this general sequence.
Right. First, you kick things off by filing a petition to open the estate.
Then you have to carefully notify all the heirs and creditors, both known and potentially unknown.
Next up, the court validates the will, if there is one, and officially appoints the executor or administrator.
After that comes the detailed inventory and appraisal of all the estate's assets.
And then the crucial step of paying off all the legitimate debts and handling all the taxes.
The executor then puts together that detailed distribution plan and gets the court's okay.
And finally, the assets actually get distributed to the beneficiaries, and the estate is formally closed with the court.
You know, something that really stands out when you lay it out like that is the court's role. It's overseeing things pretty much the whole way through. It acts as this vital oversight mechanism, making sure everything's done fairly and according to the law. It really speaks to the structured approach needed when dealing with someone's legacy.
Yeah, definitely. And it's worth saying again, this whole process from start to finish can easily take months, sometimes even years, right?
Right.
Especially if things get complicated or people disagree. But hopefully, after this deep dive, you feel a lot more informed about what's actually going on behind the legal curtain when someone passes away.
And maybe this leaves you with an important question to think about. Given how complex probate can be and how long it can potentially take, what steps could you maybe take today to make this whole process simpler for your own loved ones down the road? Because understanding the process, like we've done today, that's really just the first step. It's the proactive planning beforehand where you can make a huge difference. It really makes you appreciate the power of having a solid estate plan in place, doesn't it?
It really does. A lot to think about there. Well, if you found this exploration of probate helpful, maybe think about other complex topics, legal, financial, whatever you'd like us to tackle next time. Let us know.